Let's get this out of the way. Contracts, part 2. Nobody likes thinking about contracts, but we need to know it. I'll try and make this as painless as possible for you, and also for me. I'll timestamp each of these sections so you can skip to what you need to know. Make sure you watch the first contracts video because that's where I talked about the most important things to look out for in a contract. It's called Things to Look Out For in a Contract. This is a functional, practical video. I'm not going to make any attempt to be entertaining at all. I seriously can't stress that enough. This is going to be like learning geography at school. Don't expect to be entertained. That said, if you like the look of this lovely big brave puppy, then hit the subscribe button. Oh, I said subscribe, damn it. Warranties and indemnities. And you'll see this section in most contracts. Sometimes they'll be separate, sometimes they'll be together. Warranties are promises that particular statements in the contract are true. Some examples might be that the illustrations you are delivering are completely your own work and you have the right to sell or license them, or that the work you are delivering isn't already licensed to any other client. So this is quite straightforward, really. Read the statements. If they are true and you can legally promise that they are, it's no problem. If you can't promise that the warranties are true, then you could potentially be accused of breach of contract. Things can be adjusted if necessary. If the illustration has previously been licensed on a non-exclusive basis to another client, you might want to adjust the wording of one of these warranties so it is factually accurate. The reason warranties are in here at all is so if you, for example, copied another illustrator's work for this project with your client, and then later down the line the person whose work you copied tries to take legal action against the client, they have proof that you promised them it was original work, therefore it's your fault and not the client's. An indemnity is also a contractual promise to compensate the client if the client suffers any financial losses as a result of a breach of contract on your part. If that artist that you hypothetically copied takes the client to court for using copies of their work, there will no doubt be legal expenses for the client to get it sorted out. Legal fees, possibly loss of earnings, maybe even the cost of recalling certain products with those designs on them, or paying a settlement fee to the artist. So for warranties, you're making promises, and indemnities, you're agreeing to take the consequences of breaking those promises, in a nutshell. So you can see why warranties and indemnities are often presented together in contracts. They're linked. Unless you're lying about your work or planning something bad, then there's nothing for you to worry about here. What I would say is for warranties, you want the contract to say these promises are true to the best of your knowledge. There's always the possibility of a problem that you didn't know about. In that case, you don't want to be held responsible for something that you weren't aware of. For indemnities, equally, you only want this to be possible for actual breaches of contract, not just alleged breaches. Sometimes there might be an alleged problem that later turns out not to be true. Assignment. In the previous video, I told you to look out for the word assignment in relation to copyright, and you should. That was referring to the copyright or grant of rights section of the contract. But there may also be a specific section in the contract called assignment. And this has a different context and meaning here. This refers to assigning the obligations of the contract to a third party. For example, the client probably doesn't want you subcontracting the illustration work to another illustrator. And this isn't majorly important, I don't think, for an illustrator, but I thought it was worth mentioning just in case there was any confusion about the word assignment. Entire agreement. I've spoken about this before somewhere, I think, but the entire agreement clause in a contract means that once signed, the contract is everything. Any agreements that have been made previously by phone or email, any deal that you had agreed to with the client before will be replaced by the deal in the contract. So you need to make sure that the contract reflects the deal that you've made with the client completely, because if it doesn't, the client is only legally obliged to uphold the deal that is in the contract. Third-party rights. Contracts are usually only valid between the two parties that have agreed to them. But let's say your contract is between you and an advertising agency. The advertising agency in turn has their own contract with a car manufacturer, their client, the third party in this case. If anything were to go wrong with the project, like there was a breach of contract, if you don't have a third-party rights clause in your contract, then the car company could take legal action against you. And this is a kind of a tricky one to understand, I think, but really it's all about limiting your liability, your exposure to risk. You want to know exactly who your contract is with. If you and I enter into a contract, it shouldn't really be anything to do with anybody else. That's the way it should be, I think. You don't want to get into a situation where there's a third party, someone that your client is involved with, that you have nothing to do with directly, that can enforce the terms of the contract. To borrow an example from this book, which I highly recommend if you're in the UK, an illustrator was commissioned by a publisher to illustrate a book, and during the course of the publication, the original artwork was lost. The artist wanted to take the publisher to court for the loss of the work. The publisher said, you have to get your compensation from the printers. They're the ones that lost the work. But the publisher was wrong. The artist didn't have a contract with the printers. They had a contract with the publisher. So they would have to sue the publisher. Then the publisher would have to sue the printer for its losses. It's hard for me to really think of another example, but just consider who else might want to enforce the contract. It's not something you should worry about too much because there are very few situations where there would be a problem. It's pretty standard for it to be in a contract too. So look for it. If it's there, check it off your list. That's fine. If it's not there, you might want to ask for it to be made clear that no third parties should have any rights in the contract. Insurance. You're not required to have insurance as a freelancer in the UK in most cases, but some contracts may require it. Technically, you shouldn't sign it if you don't have it because that is a breach of contract. Hopefully, you'll never need insurance, but even if you don't encounter this in a contract, you might want to consider insurance anyway. That would probably be professional indemnity insurance, which will cover you if you get into legal trouble or something like that, and loss of earnings insurance, which covers you if you get ill long term and you can't work. It doesn't make sense to get insurance as a complete beginner, but once you're illustrating full time and working on regular projects, you should probably consider it. Employment status. This one's straightforward, but the companies you work for as a freelancer will want to make it absolutely clear that you are not an employee of the company. You are a freelance consultant or service provider. This is useful for them because as a freelancer, they are not responsible for any employment benefits their other staff might receive. They don't have to deal with your tax, and they're not on the hook for any of your possible misconduct. It's also useful for you because if you were an employee of the company, in all likelihood, the company would keep the rights to any of your designs. Power of attorney. The contracts I have between the agency and the illustrators we work with have a power of attorney clause in them. This gives the agency the right to sign certain contracts on behalf of the illustrators for their projects. The illustrators we work with don't necessarily want to get involved or deal with contracts themselves, so they give us the right to do it on their behalf by granting us power of attorney. That's part of an agent's role. But you don't necessarily want your client to have that right. There are probably some legitimate reasons for certain kinds of clients needing it, but you should question it because most of the time they probably don't need it. If they give you a reasonable answer, then fine, it's unlikely to be abused, but if they can't tell you why they need it, then they probably don't need it. Boilerplate terms. Last section here is just to explain what are referred to as boilerplate terms, which is a term you may have heard of. These are parts of a contract that are considered standard in a company's contract from one job to another. It's the section of the contract that more or less stays the same for whatever project they're working on. And this part might include some of the things I've already spoken about, like confidentiality, assignment of the contract, the entire agreement clause, third-party rights, but also things like the terms for terminating a contract, general terms for how disputes would be resolved, and the governing law by which the contract would be examined, meaning which country's laws the contract would be measured by. And probably it'll also have a force majeure clause, which at one point might have been referred to as acts of God. You wouldn't be obligated to fulfill the contract if your house was destroyed by an earthquake or a flood, for example. or if you became terminally ill or something like that. I think I've covered everything I want to hear for regular contracts. If you have any specific questions, stick them in the comments and I'll respond, or feel free to email me. If this has been useful, give me a thumbs up. I might do another one of these sometime in the future, specifically for publishing contracts, because they have their own specific parts. That's it. Fun's over.